Hi besties, it's Judgment Day for Blake Lively. Well, summary judgment day. And if this summary judgment is granted in full, and to be fair, we don't know yet whether it will be, this could mark a massive collapse of Blake's lawsuit. And Wayfair came out swinging. Justin Baldoni, Jamie Heath, Jen Al, Melissa Nathan, and Steve Sarowitz all filed a united, extremely aggressive motion, and it is loaded with receipts. And when I say loaded, I mean over 200 attachments. Most of those are currently filed under seal, but only for 1 week. After that, Blake has to decide what she wants to keep sealed. Wayfair already told the judge that they believe all of this should be public, including Blake's deposition testimony, because this is a major dispositive motion. And we already know that the judge has previously unsealed key documents tied to dispositive motions, saying the public has a right to know what evidence is shaping the court's decisions. Here's the other big thing Wayfair did: they voluntarily unsealed their own depositions. Justin, Jamie, Jen, Melissa, Steve, all of them. Not the full transcripts, but enough for the public to finally hear their side from their own mouths. But before diving into the motion itself, this is worth saying. The summary judgment is written by Alexander Shapiro, and what stood out immediately is how different his tone is from the earlier filings. One of my early criticisms of Wayfair's responses, especially around Justin, was that they leaned too hard on Blake's lying, or Blake misinterpreted things, which can come across as victim blaming no matter what the truth is. This filing avoids that entirely. Instead of arguing about whether Blake exaggerated or misunderstood, this motion focuses strictly on legal standards. What qualifies as sexual harassment, whether Blake was an employee or a contractor, whether the conduct meets the definition of severe and pervasive, whether retaliation can even be established based on the timeline, and whether the case belongs in front of a jury. It's a much more legally grounded, emotionally neutral response, and that will matter. The core of Wayfair's argument: Blake controlled the production, not them. A key requirement in a sexual harassment claim is a power imbalance. You need to show the defendant had control over your employment. Wayfair's filing argues the exact opposite. They open by calling Blake an immensely powerful A-list actor, generous, but okay, who willingly signed on to star in a film based on a book with explicit themes. They acknowledge that she raised concerns early in production, and they don't dispute that. They don't argue about whether the comments happened or whether she felt uncomfortable. What they do argue is this: Blake's complaints were addressed, the behavior stopped. She continued filming without further incidents, and her own lawyers agreed that a formal HR process wasn't necessary. That point is huge. Wayfair included communications from Blake's previous lawyers, saying the informal resolution was sufficient instead of a formal complaint process. If the conduct doesn't meet the threshold requiring HR action, how can it meet the threshold for a lawsuit? The motion claimed she was not an employee. This is another massive piece. Federal discrimination law, including sexual harassment, applies to employees, not independent contractors. Wayfair says Blake was a contractor. She controlled major creative decisions. She even refused to sign the final contract. Her power over production decisions exceeded. There she dictated the set environment, and she used her influence to push Justin out of marketing and premiere events. If the court agrees she wasn't an employee, most of her claims vanish automatically. The real conflict was creative, not sexual harassment. Wayfair's timeline argues that once the initial onset issues were resolved, things were calm. Until editing began. That's when the creative war began. Blake wanted more control. She allegedly pushed Justin out of marketing. She contacted the Producers Guild. She and Ryan allegedly disparaged Justin to industry contacts. She urged Sony to minimize or remove his film credit. She allegedly tried to have him excluded from the premiere. That, Wayfair says, is what forced Justin to hire crisis PR, not her early complaints. Not retaliation. Just self-preservation as a director, being iced out of his own movie. The smear campaign claim falls apart in discovery. Wayfair points out something brutal. After months of discovery, subpoenas to dozens of creators, and daily motions to compel, Blake still has not identified a single false statement spread by Justin or Wayfair. Her own interrogatory responses reveal no bots, no fake accounts, no coordinated harassment, no defamatory stories. Only Justin defending himself or promoting positive coverage. and any backlash she faced stemmed from her own public missteps, cross-promotion. Unfollowing Justin, premiere drama. etc. Wayfair's line. Blake doesn't object to lies, she objects to the truth being amplified. And legally, the truth is the strongest defense. The Van Zandt subpoena makes another appearance. Wayfair again emphasizes that Blake initiated the lawsuit, used a defective, out-of-state subpoena, obtained material she shouldn't have, and is now trying to recast Justin's PR response as retaliation months later. Wayfair's message. The timeline alone destroys her retaliation claim. The legal standard for sexual harassment. The filing leans heavily on Second Circuit case law. To qualify as workplace sexual harassment, conduct must be severe and pervasive, based specifically on gender, physically threatening, humiliating, or highly degrading, or something that interferes with work performance. Examples Blake cited: sexy comments asking her weight, fat-shaming allegations, showing her a childbirth video that she interpreted as porn, Jamie walking into her trailer, body-related remarks, set hugs. Wayfair's argument. These are offensive or awkward but not legally harassment, especially in a film with sexual themes, and especially when the behavior stopped immediately after being addressed. Maybe there was just an overly friendly atmosphere on set, but even incidents that made her personally uncomfortable don't automatically create a hostile or abusive environment for women. The complaints about hugging are especially strange. Her makeup artist described it as odd that people hugged so much on set, but that isn't gender-based misconduct. And when it comes to conversations about consent or pornography, those were not directed at her because she was a woman. Those were topics Baldoni talked about openly with both men and women. He did TED Talks about these issues, wrote books on them, and spoke about them in mixed company. They can show proof that he never isolated these conversations to her. Even the birth video wasn't something shown only to a female actor. Both Heath and Baldoni saw it. Nothing about that makes it inherently sexualized toward her. Simply glancing at her also doesn't make something sexually motivated. Her case relies on the flawed assumption that any unwelcome reference to sex or sexuality automatically equals gender discrimination. That isn't the law. Courts have ruled repeatedly that even overtly sexual behavior, even far more extreme than anything she alleges, does not qualify unless it's specifically motivated by gender. They cite Brown v. Henderson, where the plaintiff faced crude jokes, threats, and even pornographic images in the workplace. Yet the claim still failed because she couldn't show the conduct was based on her gender. Men were part of the conversations too. Other cases rejected claims by a bartender exposed to nudity and explicit acts, and even a writer on Friends who was surrounded by sexual humor, because both men and women participated equally. If Blake hugged people too or made comments about things being sexy, she can't reinterpret similar conduct as harassment targeted at her. They also argue that the studio remedied every concern she did raise, and that none of this meets the standard for retaliation either. To claim retaliation, she would need to show an adverse action like being demoted, sidelined, or paid less. But none of that happened. She actually gained more control. And the timeline doesn't work. Wayfair addressed her concerns immediately, months before any media controversies. There's too much distance between her complaints and any of the later publicity to claim a causal connection. Baldoni putting out positive press about himself isn't retaliation, it's normal. PR. Pointing journalists toward existing negative coverage of Liability isn't actionable either. Courts have consistently ruled that even contacting tabloid outlets isn't retaliation when it's a reasonable defense of one's reputation. They point out she can't prove anything they said to the press was false or defamatory. She hasn't sued Jen Abel, Melissa Nathan, the agency group, or any PR professionals for defamation. The only defamation claims she's made relate to statements made after this lawsuit began, statements issued by Friedman on behalf of his clients. She's also alleging a digital warfare campaign, but discovery shows it never happened. In August 2024, long before any conflict, Baldoni asked his PR team multiple times whether they were using bots or fake accounts, and they told him explicitly they were not. Throughout the filing, they returned to Second Circuit rulings defining harassment, retaliation, and causation, and they argue that Blake herself contributed significantly to the publicity battle. She launched public attacks, and the moment there was any defensive response, she escalated further. On the same day, she claims the smear campaign began August 9th, There was already activity by her own team. By August 13th, she and her team filed what they describe as a bogus lawsuit in New York, and then coordinated a 4,000-word New York Times article built on cherry-picked, improperly obtained texts from Abel's phone. Her own aggressive media tactics take the situation far beyond workplace-related laws. One of the biggest issues for her claim is identifying the protected activity. She has to prove that whatever she reported was the direct, necessary cause of any adverse action. But there is no temporal proximity. 8 months passed without a single negative consequence after she raised her concerns. Filming resumed without issues, including the intimate scenes she now claims were unsafe. During that entire time, she didn't file new complaints, and during her sealed deposition, she apparently tried to introduce new incidents she had never documented or reported before. They argue she can't establish causation because it's unreasonable to believe they hire PR professionals due to concerns she raised 8 months earlier. They hire PR because of what they describe as her own actions freezing Baldoni out, isolating him from the cast, excluding him from the premiere, and launching negative coverage. They say these were legitimate reasons for reputation management regardless of her internal complaints. A separate fatal problem is that she has to be legally considered an employee to bring a sexual harassment claim under Title VII. Their position is that she wasn't an employee at all, she was an independent contractor who controlled everything. They list example after example. She moved the filming location, changed the schedule, held production meetings at her home, demanded terms and conditions, insisted on specific protections, exercised creative authority over script and editing, and repeatedly refused to move forward unless her conditions were met. Her star power gave her more leverage than anyone else on set, the opposite of a vulnerable employee with a boss. They walk through the standard legal checklist to determine employment. She didn't sign the agreement personally. Her loan-out company did. She controlled the manner and means of her work. She determined when and how she would perform. She bargained for a $1.75 million guaranteed payment, plus bonuses including a box office bonus matching Baldoni's. She served as her own creative force. She directed major decisions from location changes to scene adjustments. She even bragged about her creative control in her PGA letter, something they say now undermines her claim of being powerless. The location move from Boston to New Jersey was her idea purely for convenience. They repeatedly cite her PGA letter because membership implies producer-level authority, not employee-level subordination. She wasn't hired for multiple projects. She was contracted for a single production. Her schedule was heavily negotiated. Payments went through an escrow agreement. She hired her own assistants, nannies, and security. She never received employee benefits, and she was not taxed like a W-2 employee under New Jersey law. She handled all her own taxes like an independent contractor. Her claim that they failed to investigate her concerns also doesn't stand up, they argue. Because there was nothing left to investigate, her concerns were addressed. Protections were implemented, and she later agreed everything was fine. She never made a formal HR report. They then addressed the contract issue. Since the agreement was never signed, they argue it can't be breached. The writer terms were incorporated into the unsigned loan-out agreement, and therefore nothing was ever fully executed. There was no consideration, no completed formation. But even if the court were to assume the contract was valid, they say her claims would still fail for additional reasons they outline afterward. Their first argument is simply that the contract was never enforceable to begin with. They argue that the undisputed facts show both sides clearly intended not to be bound unless the full agreement was executed. This is based on the explicit condition precedent language and the draft ALA language. Blake refused to remove along with their repeated efforts to obtain her signature through July 2024 and her continued refusal to sign. Because she never executed the agreement, they say she can't enforce terms from an unsigned contract. And since the contract writer agreement, CRA, was incorporated into the main ALE, she also can't claim breach of the CRA, which was never intended to be a standalone document. From their perspective, they did everything they could to finalize it. The record shows both sides were still negotiating material terms up to July 24th, meaning no final agreement was ever reached. The only document they agree was actually finalized was her offer letter from May 2023, something she accepted by beginning services. However, the offer letter does not contain the terms she now claims were breached. For that reason, even if the offer letter is enforceable, it can't save the rest of her breach of contract claims. They emphasize that nothing in the CRA suggests it was independently enforceable. It was plainly an add-on meant to supplement the final ALE once signed. Her own counsel's conduct during negotiations shows everyone understood the CRA was only an amendment to the larger, still unfinished agreement. A huge portion of the contract arguments boil down to two paths the judge could take. The agreements were executed, so nothing beyond the offer letter can be enforced, even if the judge treats them as enforceable. Blake still can't win because she didn't follow notice requirements. They cured every issue she raised, and the damages she's seeking are barred by the very terms of the contract. Next, they argue that Wayfarer was not her employer under the law. Filmmaking companies routinely use single-purpose entities like It Ends With Us Productions to segregate budgets and liability. Blake sued Wayfarer instead, even though the employer-employee relationship she claims existed would have been with the production entity she didn't sue. They insist Wayfarer is not an alter ego and cannot be held responsible as if it were. Her damages claims also run into multiple legal problems. The contract bars certain damages including punitive and treble damages, and she cannot seek lost profits for businesses she merely owns shares in. She's attempting to recover money she claims other entities lost, but those entities aren't plaintiffs in this lawsuit. Courts routinely reject individuals trying to recover corporate losses on behalf of companies, and they highlight that these businesses are brand new, making projected profits far too speculative. They also address her allegations about Wayfarer financier Steve Sarowitz. They say he had almost nothing to do with the film's production and that the supposedly threatening statements attributed to him never occurred. In context, his actual comments were about defending the studio, not destroying her life or career. For defamation and false light, they repeat what they argued in earlier motions. Everything the defendants said was protected by litigation, privilege, and related to defending themselves once Blake went public. New York doesn't recognize false light as a cause of action at all, and her conspiracy claim collapses because all the underlying claims fail. Their summary judgment motion directly challenges the foundations of her case, whether this was sexual harassment under the law, whether she was an employee, whether she suffered any adverse employment action, and whether her claims meet even the basic legal standards. They argue she cannot prove discrimination because none of the conduct she described was targeted at her, because she's a woman. They point out that men were part of the same conversations, saw the same birth video, and participated in the same behavior, meaning it wasn't gender-based. They also stress that Blake herself exercised enormous control on the production. In fact, they say the record proves she had more power than anyone else. She moved the filming location, modified the schedule, rewrote scenes, took over elements of production, led meetings at her home, and continuously issued demands that the studio adopted. Her own PGA letter, where she insisted on receiving producer credit based on her creative control, is now being used against her. It undermines her claim that she was a powerless employee subject to someone else's authority. Sexual harassment law is designed to address power imbalances, and they argue Blake held the power, not them. On retaliation, they say there's no causal link. She made her complaints, they implemented protections, filming resumed smoothly, and months passed with no issues. The media stories she complains about came nearly a year later and were, in their view, normal PR responses to her escalating public attacks. They say she started the publicity war, manipulated the narrative, and then treated any pushback as retaliation. Under the law, PR damage control is not an adverse action. They also highlight that she never filed an HR complaint, never identified a specific protected activity, and did not suffer any demotion or loss of pay. In fact, she got more control and maintained her full compensation. They note she even tried to bring up brand new accusations, and her deposition claims she never raised when the events supposedly happened. Their bottom line, nothing she alleges meets the legal definition of sexual harassment, retaliation, breach of contract, defamation, or conspiracy. And because she never signed the operative agreements and wasn't even their employee, the entire case should be dismissed. They filed over 1,000 pages of exhibit stacks, emails, depositions, contracts, negotiations, arguing there are no disputed facts that justify going to trial. Blake, despite promising to file her own summary judgment motion, never did. That means she isn't arguing the facts are so clear she should win, only that she disagrees with their interpretation. Will the judge agree with every argument Wayfarer and Baldoni made? No, judges rarely adopt every point. But they gave the court multiple independent legal pathways to dismiss the case. Even if one theory fails, another may succeed. Between this motion and the earlier motion for judgment on the pleadings, the judge has two separate procedural options to throw out most or maybe all of her claims. If this goes to trial, it will almost certainly be on a dramatically smaller set of claims. A large portion of her lawsuit is likely to be dismantled through these motions, especially the most explosive accusations. Blake will respond and she fight every line. But she now has to argue two contradictory positions at once. The pleadings were legally sufficient, and the facts are disputed enough that summary judgment can't be granted. That is a difficult place to stand. Wayfarer's strategy was smart. They didn't rely on only one argument, they attacked every angle: employment status, contract validity, damages, retaliation, defamation, jurisdiction, timing, evidence, and her own conduct. After months of staying quiet, they hit the court with everything at once and told the judge, "Here's the full picture, now you decide." So, what do you think? Let me know your thoughts in the comments below. If you enjoyed this breakdown, make sure to give the video a thumbs up, subscribe to the channel, and hit the bell so you never miss a new upload. Thanks for watching, besties!